Aref, thank you so much for being here with me today. I know you have a busy schedule. You're in Canada right now, no?
That's right.
Okay. How come? What's on the agenda?
In Canada, I attended a colloquium of the Maritime Law Associations of the Comité Maritime International, which is a federation of national maritime law associations. It is also partly my home city, Montreal, where I actually went to university and practiced in the first years of my career.
Okay. Okay, so it must be really nice to be home.
Very much so.
All right, so I would just like to quickly introduce us both. So my name is Held. I'm a research fellow at the Konrad Adenauer Stiftung, the Rule of Law program for the Middle East and North Africa. We're based in Beirut in Lebanon. And Aref, you've been an expert of maritime law for over 30 years now, and currently you're an associate professor at the World Maritime University, which is based in Malmö, Sweden. Today, we would like to talk about the paper that you wrote for our office about a deal which is known as the Maritime Border Deal, struck in October 2022 between Lebanon and Israel. The agreement put an end to a decade-long dispute and established a permanent maritime boundary between the two states. Given the very complex and difficult relationships between the two neighboring states, the deal was hailed as historic, and many are hoping it could pave the way for a more peaceful relationship between them. My first question would be if you could briefly summarize the dispute that was going on between the two countries and how the deal is now putting an end to this dispute and what it really says.
Well, the relations between Israel and Lebanon were, to say the least, tense for many centuries, many decades. And I think the issue of the maritime dispute emerged in the last decade or so, when I think states in the Eastern Med started to realize that there were finds of oil and gas offshore. And that's when I think states started to actually turn their attention to the maritime zones, to whatever was lying under the sea. So I think one could place the year 2010 as the start of that buildup of a dispute opposing, I would say, Lebanon with Israel. The dispute went through a couple of stages. It went from the standard simmering because of the difficult relations between the two states. So obviously there was no direct actually contact between the two sides. So it simmered for a while. I think the U.S. also took a part in appeasing the conflict or the dispute by mediating more than once. Initially, the U.S. mediator did propose a settlement, but that was not agreeable to the parties. We're talking of the so-called Hof demarcation line in the early part of the 2010s, and then later on with kind of a morphing also of the claims. The claims started morphing, especially on at the behest of the Lebanese side. With I think arguably the backup studies that buttressed a kind of a wider claim on the Lebanese side. There was obviously a potential for escalation of the dispute, and that was really getting kind of out of hand. So the U.S. actually again intervened, and with the facilitation by the United Nations all along, and they managed eventually on the 27th of October of 2022 to bring the parties to seal an agreement formally between them, delimiting once and for all the maritime borders between Lebanon and Israel. So that, in a nutshell, is what has been going on for the last 10 years plus in that part of the world.
Okay, I see. But so the questions we were mainly asking ourselves in the office were, how can this treaty be seen from an international or public international law perspective? Is this, so just generally, maybe, what does public international law, say about the law of the treaties? What kind of main components should a treaty have? What are the guiding principles? And is this treaty, if you apply those principles, can this treaty be seen as a treaty under public international law?
According to the international law, and I'm referring here to one particular instrument that lawyers and diplomats refer to, which is the Vienna Convention on the Law of Treaties of 1969, which is widely ratified, even though it's not ratified actually by Lebanon or Israel, but it's considered to be very much representative of the international law. There's a very terse and brief definition of what a treaty is. Of course, it's important to refer to it, and it says simply that a treaty means, I'm just actually now reading it out, means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. One can also, on top of that, build on the kind of constituents of that treaty that is defined in the convention by looking at the parties to the treaty, the actual conclusion of the treaty, the specific document, because of course the treaty does refer to the fact that it is in written form. So one should look at what was used by the parties to see if the documentation, in fact, represents an instrument or a written form that meets the requirements of that definition. There are also ingredients in a treaty like the entry into force of the treaty. So all of these conditions are actually laid out more or less clearly in the Vienna Convention. And one actually can go through each one of them and relate it to what actually the two states in this scenario, Israel and Lebanon, were negotiating and eventually concluding. And I don't know if you want to, you've asked me for that already, but I can, on the basis of the report that your office has published, I think my view is that it is the agreement concluded between Lebanon and Israel does constitute a treaty in international law on the basis of what I just described.
Okay, so just because I remember originally all that was known to the public or accessible to the public were letters, right? An exchange of letters between the two governments. Do we now have know that there is an actual treaty, and has this been, does the UN have any sort of treaty that is accessible to the public?
Actually, just to be correct, there was no exchange of letters between the two negotiating states, that is Israel and Lebanon, but rather letters addressed to Lebanon or Israel by the United States mediator, and vice versa. So Lebanon and Israel were writing back letters to the U.S. mediator. So there were never actually any letters exchanged directly between Lebanon and Israel. And that is really interesting in this context. So even though the agreement ultimately is between Israel and Lebanon, there was nothing actually exchanged. No instruments were exchanged directly between those two parties. And even more so, there was no signature of any single document between the two sides. So all we have are, as we said, letters, really official letters, that is, exchanged between Lebanon, Israel, and the U.S. mediator. Yes, I think to dispel any misconception, the definition of a treaty in international law does not require that states actually, to a treaty, sign anything together in one document, or that they exchange directly the letters. It can be done in any way, and that's how it's spelled out in that definition I read out to, earlier. I think the international law is quite flexible as to the ways in which treaties can be formed, and in this particular instance, I think again, I think that we have gone through the exchange of letters, and of course the annexed terms and conditions to those letters, and in my opinion, as a lawyer, I felt that it was, or I came to the conclusion that it was pretty much a treaty in the ways that it has been put forward. In fact, I think we were kind of prejudiced by the fact that when the my report to you was concluded, there was still no publicly available official text or official copy of the exchange of letters. There was, however, at the time, and this is referenced in the report, so the readers can actually go to the reference and click on the link, and they will be taken to the deposit or the record of the deposit by one of the two sides, that is Israel. So the Israeli side, or the state of Israel, did eventually, after the conclusion of the agreement, deposit with the United Nations Secretary General a copy of the exchange of letters, which forms the agreement. So it's very clear now on the website of the UN treaty collection. As I said, it's in the report, that you will find, or any reader can find, the official one official copy, or one official version, really, of that exchange of letters.
Okay, great. That's very insightful. Thank you. So just coming back to your legal analysis, what if any of the parties violate any clause in the document or in the agreement? What is there any mechanism in place to implement the treaty or the agreed lines, and how is there any also accountability mechanism?
Yeah, one would have to say that a treaty in international law is binding on its parties. So that's a first principle, which is kind of reflected also in the paper, and we did reflect that, and we gave the basic provisions in the Vienna Convention on the Law of the Sea, on the Law of Treaties, that talks about the binding effect of treaties. So a treaty does bind the states that are party to it. I think that means what it means. It means that the treaty has to be implemented by the parties. So the parties have to respect that, because that is based on international law. A treaty is usually binding only on the parties to it. So Israel and Lebanon in this case. The agreement in question, and I've been using obviously the words treaty and agreement kind of freely, but the agreement is a treaty and vice versa, to make it simple. The agreement in this particular instance doesn't really elaborate much on what may happen in the case of non-implementation or default by one of the parties. There are some provisions about what states should be doing in certain instances, but ultimately there is no clear dispute resolution mechanism ingrained in this document, or in this exchange of letters, really, which constitutes the agreement. The only provision there is a provision that allows the U.S. mediator to help resolve conflicts amicably between the parties, which is an acceptable form of dispute settlement in international law, but it doesn't go to the extent of, for instance, providing for a compulsory jurisdiction for an international court or arbitral tribunal if one of the parties defaults. That is not in the agreement, so it may be a bit tricky if the good offices of the U.S. mediator fail to bring about a settlement. There is no provision for resort to arbitration or to a court for settling the dispute. So that has to be like agreed to by the parties ad hoc or there and then, because in international law, you need a very explicit agreement to refer a dispute to a court or tribunal.
Yeah, okay. Okay, and do you know if there has been any incident since the treaty was signed or the agreement was reached? Have there been any disputes, or has it been going relatively well, given also the fact that it hasn't been a year, so hopefully it should be going well?
As far as I am aware, there hasn't been really a major issue with the working of this agreement on the ground or on the water, because it does actually relate to a maritime zone. There has been some talk in, I think, the media or the press about, you know, some sort of second thoughts about the agreement on, I think, both sides, both immediately after the signing or the conclusion of the agreement. I don't want to use the word signing again, because nothing was signed between the two parties, but rather, as we said, it was an exchange of letters. So yeah, and more recently, I think we had also an instance of questioning by one of the sides also, or by some leaders, perhaps in one of the two states, of the worth of the agreement and whether it should be complied with, or whether it should be just discarded and we go back to square one. But I think that because of the principle I was talking about earlier, after all, that it's a treaty, so it is binding on two states, on the parties to it. I think it's a weighty principle of international law, and the two states have to kind of live with that, really. So in actual fact, there hasn't been much of an issue, really, in terms of the life of the agreement, and the fact that it is still holding.
Okay. All right, great. So I think we've covered most and the main questions that your paper also covers, and it obviously goes into way more detail. So I would recommend everyone that's interested in this topic to go to our website and have a look at it. I'm really grateful that we were able to have this conversation despite the busy schedules. I don't know if there's anything else that you think should be mentioned regarding the contract or the treaty, the agreement, or if we're good to go.
I think, Valeska, I want to thank very much the Konrad Adenauer Foundation, yourself also, who have been a very ardent supporter of the initiative, and of myself in doing this study, which I hope will shed some light on the legal aspects of the paper, of the agreement. And that it is important to move aside all the discussions about the socio-political, economic issues also related to that agreement, because as an international community, states and the world really are governed by international law. So we need like more kind of lawyers to assess where this is taking us, because that is ultimately how the world functions. It's based on ultimately international law, the United Nations Charter, and the rest of the treaties. So I think it's been a good window for us as a team, and I very much enjoyed working with you, to really capitalize on the legal value as such, detached from all the rest of the considerations, which I'm not saying are worthless, but somehow they represent different interests, and one should reflect on the legal aspects, because it's, after all, a legal document.
Absolutely, I couldn't agree more. Thank you for saying this. And it was also a big pleasure on my end to be able to work with you, and hopefully, we'll see how things evolve, and if there's any new developments in the coming years or maybe months. So we'll stay in touch. Thanks again.
Thanks, guys.
See you very soon.
Thank you very much. All the best. Have a good summer.
Bye.